together and our respondents are in another room together. And so they're going to need a minute between their two arguments to change their names. So there may be a brief pause while they're making that tech adjustment. And then, of course, after the arguments are concluded, y'all will fill out the online survey for the scoring, and then there's 15 minutes allotted for feedback to our litigants today. Chief Justice Boylan, are you ready to proceed?
Yes, I am.
All right. Hear ye, hear ye, hear ye. The Supreme Court of Texas is now in session. All those with matters to present shall come forward to be heard. Pending before the court is cause number 20-0001, City of Balboa Bay versus Bluth, before Chief Justice Boylan, Justice Crozier, Justice Wolbert, and Justice Galvan. Petitioner may begin upon instruction from the Chief Justice.
Counselor, you may begin.
Thank you, Chief Justice, and may it please the court. My name is Rolando Reyna, and together with my co-counsel, Laura Smith, we represent the petitioner, the City of Balboa Bay, in this matter. At this time, I'd like to reserve 2 minutes for rebuttal. Now, there are 4 certified questions before the court today. I will be addressing the first 2 jurisdictional and procedural issues, while Ms. Smith will be addressing the preemption and tort claims. Now, with regard to those first 2 issues, the questions before the court are, first, whether this court even has jurisdiction to hear the merits of the case because of the timeliness of respondent's en banc motion. Now, the answer is no, because the respondent's motion was untimely. Second, whether the appellate court had interlocutory jurisdiction because of a substantive ruling requirement that was not met by the trial court judge. Now, the answer to this question is yes, because there is no substantive ruling requirement. And it's because of this that we are asking this court to remand this case with instructions to hold that the en banc motion was untimely. Now, in the alternative, this court should hold that there is no substantive ruling requirement and rule consistently with the appeals court's grant of summary judgment in favor of the city. Now, moving to that first issue, this court has no jurisdiction to rule on respondent's en banc motion because respondent's motion was not timely because there was no change in the judgment or opinion between the filing of the motion for rehearing and the motion for en banc reconsideration. Now, this is true for 3 reasons. First, Rule 49 treats both rehearing and en banc motions the same for the purposes of procedure and filing. Second, the when permitted language in Rule 49.5 in Rule 49.7 is a reference to all constraints put onto these types of motions, including the constraints in Rule 49.5. And third, respondent's interpretation of this rule is inconsistent with the rules of statutory construction and is antithetical to the goals of the appellate rules of procedure. Now, moving to that first point, when you look at Rule 49, you can see that it's drafted in a way to note the practical differences between motions for rehearing and motions for en banc reconsideration while still treating them the same. First, if you look at the title of Rule 49, it is motions for rehearing and en banc reconsiderations. And if you notice, it almost tries to split it up. It puts motions for rehearing in Rules 49.1 through 5, and then in 49.6 is the first time we hear about motions for en banc reconsideration. So when you look at Rule 49.7, the first 2 sentences of Rule 49.7 were added in 2008, in a 2008 revision to this rule. And in the comment that accompanies that 2008 revision, it states that the rules were revised in order to treat a motion for en banc reconsideration as a motion for rehearing and to include the procedures governing the filing of a motion for en banc reconsideration. So right there in the comment, it already states that the rule was revised in order to treat motions for rehearing and en banc reconsideration the same. Now, respondent may point out that some, but not all of the rule subparts mention both types of motions, which now, although that may show that some of the subparts may only be specifically referring to a motion for rehearing or only specifically referring to a motion for en banc reconsideration, it's important to look at the rule as a whole, and especially the subpart Rule 49.9. So Rule 49.9 states that a motion for rehearing is not a prerequisite to filing a petition for review in this court. Now, in no part of Rule 49.9 does it mention a motion for en banc reconsideration. So we're not supposed to be led to believe that a motion for en banc reconsideration is a prerequisite in order to file into a petition for review into this Supreme Court. So because that rule is only referencing a motion for panel rehearing, but it's obviously including motions for en banc reconsideration, along with that 2008 comment, we can see that the terms motion for rehearing and en banc reconsideration are used interchangeably within the rules, and that a reference to one is also a reference to the other, which is why when you look at the when permitted language in Rule 49.7, you can see that when permitted is not only a reference to the restrictions placed specifically onto en banc motions for reconsideration, but also to restrictions for motions for rehearing.
But Counselor, when Rule 49.7 uses the phrase when permitted, isn't that a clear reference to Rule 49.5 that says a successive motion for rehearing is permitted only when the panel changes its opinion or judgment?
That is correct, Your Honor. Although Rule 49.5 is titled subsequent motions for rehearing and only uses the term motions for rehearing, as you can see from my first point, the rule uses rehearings and en banc reconsideration motions interchangeably. And so that when permitted.
Just so we're all clear, but didn't you argue in the Court of Appeals that the respondent's motion was untimely?
Not in the Court of Appeals, Your Honor. The en banc motion for reconsideration was the last motion filed in the Court of Appeals, and that's what has led to this petition for review. But yes, it is the position of the petitioner that the en banc motion for reconsideration was untimely.
Okay.
And so, but to get back to that when permitted language, so the that when permitted language, like Your Honor said, it's a clear reference to Rule 49.5, mainly because when permitted is a reference to all restrictions placed onto these types of motions, motions for rehearing and motions for en banc reconsideration. Now, respondent may point to the court case that came from a Dallas Court of Appeals, Cruz v. Ghani. And in that decision, they state that the when permitted language is really only a reference to Rule 49.11. Now, this is untrue because if it were only a reference to Rule 49.11, then the when permitted language would be surplusage, because Rule 49.11 is already specifically referring to motions for en banc reconsideration. As a reminder, Rule 49.11 governs that a party can't file a motion for rehearing or en banc reconsideration if they've already filed a petition for review in this court. And so because Rule 49.11 is already specifically referring to motions for en banc reconsideration, then you could take out the when permitted language and that interpretation would still stand. And so in order to give effect to the when permitted language in that rule, you need to treat it as if motions for rehearing and en banc reconsiderations are same, like it suggested in the 2008 comment, which accompanied the revision to this rule. And it's for those reasons that this court should find that the motion for en banc reconsideration was in fact untimely. Now, moving to the second issue, which is the merits of the motion. If this court were to reach the merits of the motion, then it should note that Section 51.014 of the Civil Practices and Remedy Code does not require a trial court judge to make a substantive ruling on a controlling question of law, nor does it require trial court judges to articulate their reasoning behind allowing an interlocutory appeal. Now, this is true for two main reasons. First, the plain reading of the statute does not require a substantive ruling. And second,
Counselor, I'm sorry, I'm taking to interrupt you again, but aren't courts of appeals saying that the substantive ruling requirement is in the Texas Constitution's prohibition against advisory opinions?
No, Your Honor. So the permissive appeal statute is an exception to the final judgment rule, where a party can appeal an otherwise non-appealable order, but only if certain things exist.
Is there any court that has held that a substantive ruling requirement does not apply?
No, Your Honor. Actually, every court that has come across this specific issue with regard to Section 51.014 has in fact required a substantive ruling. But really, if you look at the plain reading of the statute, there is no substantive ruling requirement in the statute, and you actually have to look to procedural rules in order to find where the substantive ruling requirement is. And that's exactly my second point, is that because this is a procedural defect through no part of either of the parties' fault nor the Court of Appeals' fault, then this court should preserve the parties' claims on appeal and affirm the judgment in the Court of Appeals, which reversed the trial court and granted summary judgment to the city. So again, when you look at the plain reading of the statute here, it really only requires four things. There needs to be an order. There needs to be a controlling question of law. There needs to be a difference of opinion, and the appeal would ultimately advance the termination of litigation. Now, nowhere in the statute does it claim that the trial court judge must identify what the controlling question of law is and must make a substantive ruling on that controlling question of law. In fact, the language specifically reads—
Counselor, but if the trial court didn't identify the controlling questions of law in its order or explain why an immediate appeal would materially advance this litigation, isn't that in and of itself a problem?
Not according to the statute, Your Honor. And that's my exact point, is that according to the statute, there just needs to be an order that's going to be appealed, which involves a controlling question of law, as to which there's a substantial ground for difference of opinion. And that's what we have here. There is a question of law in this case, and it's involved in that order. But where the substantive ruling requirement actually comes from is Civil Procedure Rule 168. Now, Civil Procedure Rule 168 requires that the order containing the permissive appeal must identify the controlling question of law and must state why an immediate appeal would materially advance the ultimate termination of litigation. So right there is the substantive ruling requirement, which is being applied to the statute. But it's in a rule of civil procedure. And it's not a rule of civil procedure that is the responsibility of the parties. It's the trial court judge who lays out the order, and it's the trial court judge who must include in the order what the controlling question of law is and what their substantive ruling on that controlling question of law was. And in this case we have a trial court judge who chose not to do their job. In fact, the record is clear in that the trial court judge punted the issues onto the appeals court and decided that it was too difficult and made a pretextual judgment on why they were denying the motions for summary judgment, and that there was a fact issue. So,
excuse me, Counselor. Under Saber Travel, the Court of Appeals always has discretion to refuse to accept a permissive appeal and not decide the case. Didn't the Court of Appeals have discretion to dismiss the appeal even after it decided the case?
Well, Your Honor, it does have discretion to do that, but this court has discretion to reverse that decision. And also the Court of Appeals had discretion to not accept the appeal in the first place. Now, the Court of Appeals failed to notice the procedural defect that was the fault of the trial court judge. In fact, both of the parties failed to notice the procedural defects. That was the trial court judge's responsibility. So what we have here is a trial court judge failing to do their job and everybody else not realizing that it was a problem. And so it is antithetical to the goals of the appellate rules of procedure, which is to provide just, fair, and equitable resolution of these issues, to, after a year or more of litigation, to decide that there was a procedural defect and we're going to dismiss this case for want of jurisdiction. And so as consistent with this court's holding in Verbo v. Dorner, whenever a bona fide attempt at invoking jurisdiction has been made by one of the parties, this court should err on the side of preserving the appeal. And that's exactly what we have here in this case. We have not only the parties' decisions, but the appeals courts all invoking the jurisdiction of the appeals courts in order to have the claims of this case heard. And so it's for those reasons that this court should first find that the motion for en banc reconsideration was untimely, or In the alternative, where it reaches the merits of the motion, find that there is no substantive ruling requirement. Thank you.
May it please the court. My name is Laura Smith, and I too represent the petitioner in this matter. Now, there are two additional issues before this court. The third issue is whether or not the Balboa Bay bag ban was preempted by the Solid Waste Disposal Act, and the answer is no. And the fourth question is whether or not Officer Taylor owed Lucille a duty of care, and if so, did he breach that duty? And the answer is no, he did not owe a duty of care. And it's for these reasons, or it is therefore we ask that this court affirm the appellate court's grant of summary judgment. Now, first turning to the question about the preemption. The bag ban was not preempted for two reasons. First, it was not in direct conflict with state law. And second, it was enacted with solely aesthetics in mind. The Solid Waste Disposal Act includes an express preemption provision, which states, a local government may not adopt an ordinance to prohibit or restrict, for solid waste management purposes, the sale or use of a container or package in a manner not authorized by state law. And this court in Laredo versus Laredo Merchants Association interpreted this to require that a city ordinance have a solid waste management purpose in mind in order for it to be preempted. And here, there was no solid waste management purpose in mind. On page 4 of the record, it states that Balboa Bay enacted this bag ban because they thought plastic bags broke too easily and just caused messes that were unsightly. And that was the reason that they enacted this statute. So, as this court in Dallas Merchants and Concessionaires Association stated, a city ordinance has to be clearly and unmistakably at odds with state law in order for it to be preempted. And in this case, there's no clear and unmistakable conflict because we simply have a statute that was enacted with aesthetics in mind. Now, we do have to state that it is in fact true that the sponsoring or author of this city ordinance did originally consider solid waste management. However, as this court in General Chemical Corporations versus De La Lastra and in AT&T versus Southwestern Bell Telephone Corporation noted that a single legislator or a single council member, regardless of whether or not they are the author and sponsor of a bill, cannot dictate legislative intent. And so again, we have to look to what the actual written purpose of this statute is. And in the text, it clearly states that Balboa Bay enacted this statute because they wanted to improve the aesthetics of the area. And it is because there is no solid waste management purpose that the Balboa Bay bag ban is not preempted by the Solid Waste Disposal Act. Now, moving to the fourth question before the court, whether or not Officer Taylor owed Lucille a duty of care. He did not.
Counselor, can we just back up a minute? I've got a couple of questions for you. But in Laredo Merchants, didn't we note that to discourage use of the plastic bags, the ordinance itself makes it unlawful for any commercial establishment to provide or sell certain plastics or paper checkout bags to customers? Isn't that right?
Yes, Your Honor.
So then, isn't it true that both here and in Laredo that the local ordinance is to discourage the use?
Your Honor, it's not aimed at discouraging the use in order to curb solid waste management or to alter solid waste management. That may be an alternate effect. However, it wasn't the purpose of the statute. And this,
So then what was the purpose?
The purpose of the bag ban in Balboa Bay was in order to increase the aesthetics of the area. It wasn't targeted at solid waste management. That's just a side effect that was a result, but it wasn't the purpose of the statute.
And also in Laredo, isn't the bag ban was intended to prevent sewerage blockages, correct?
Correct, Your Honor.
And weren't there sewer blockages in this case as well?
Yes, Your Honor. However, after conducting independent research, as the record shows on page 4, it was found that there weren't substantial sewage blockages in this case. In comparison, in the Laredo case, the damage that amounted from the solid waste was millions of dollars, and we don't have that evidence in this record to show that there was substantial damage. In fact, the findings show that it wasn't a major concern for Balboa Bay. So again, they did consider the aesthetics, and that was their primary and sole purpose for enacting this statute.
But Counselor, I thought that the whole bag ban issue started when Lucille Bluth tripped over a discarded plastic bag, correct?
Correct, Your Honor.
And that's litter and that's solid waste.
Yes, Your Honor. It is true that it started.
So then if Lindsay Bluth then had her campaign and all of the city council proceedings occurred that resulted in the bag ban. So aren't the concerns over the management of solid waste really what's resulted in the bag ban, not the aesthetics?
No, Your Honor, because in this case, she may have been injured by a plastic bag and that may have started her drive. However, that wasn't the decision of the city council. It may have brought it to their attention, but however, upon reviewing the information they had, they found that that wasn't a purpose and that there wasn't this true need to ban the bags for solid waste management. And they unanimously agreed that the purpose of this bag ban would be to increase aesthetics in the area and that it wouldn't be to manage solid waste. So it may have brought it to their attention, but the findings and the
So is your position that the effect of preventing solid waste was a byproduct of wanting to improve the aesthetics?
Yes, Your Honor, it is simply just a byproduct, but that doesn't change the purpose of it. It still is an aesthetics purpose in mind.
Okay.
So moving to the fourth question, whether or not Officer Taylor owed Lucille a duty of care. He did not owe her a duty of care because her injuries were not foreseeable and because the risk is substantially less than the burden involved in this case. Now this court—
Counsel, you just said that the risk wouldn't have been foreseeable, but isn't the whole point of lights and sirens in a police vehicle to capture people's attention? Wouldn't that make this foreseeable?
Yes, Your Honor, that is the purpose of the lights and sirens. However, that doesn't make her injuries foreseeable. Now, this court in San Antonio Railroad Corporation versus Belt noted that some vehicles just inherently have loud noises, and that because it's inherent that we'll have loud noises in that case with a locomotive and in this case with a cop car, that it's not foreseeable that a person is going to have such a volatile reaction or reaction in general, because it's just happenstance that these vehicles make these noises. And that's precisely what we have.
But this wasn't happenstance, counsel. This was the officer purposefully turning on the siren. Isn't that distinction significant?
No, Your Honor, because we anticipate that all police vehicles and all emergency vehicles will have lights and sirens that sound, and we anticipate that this can happen at any moment. And so just as a loud noise can come from a train at any moment, we expect the same thing from a police vehicle or an emergency vehicle. There's no way to know when it will happen, but a person just generally expects that it can happen.
Does Officer Taylor's intent or knowledge in the situation impact your calculus at all?
Your Honor, that goes to my second point, whether or not the risk is exceeds the burden. And in this case, the risk just generally doesn't exceed the burden. So as the Austin Court of Appeals and the Dallas Court of Appeals in Mansfield versus CF Bentry Apartment and City of Dallas versus Half Price Books respectively state, the burden we place on officers is so great that an officer's status can change from off duty to on duty instantaneously. So in this case, the burden generally placed on officers is going to far exceed the risks involved in this case.
But Counselor, in this situation, Officer Taylor was on a break, correct?
Correct,
And
Your Honor.
so if he's turning on his lights just to get out of a parking lot, after being on break, it doesn't seem like your claim about police officers needing to do their job actually assumes that a police officer is in the middle of doing their job when they use their patrol car's functions. So they'd have to be doing their job to use those lights and sirens.
In this case, Your Honor, Officer Taylor is returning to his duty. He's returning to protecting and serving.
But did he actually have a reason other than self-preservation because he wanted to get out of the parking lot faster to turn on his lights and sirens?
No, Your Honor, he did not have an emergency that he was attending to, and the city concedes on page 5 of the record that there was no emergency situation. However, if we were to apply a broad rule that lights and sirens can be only used in such narrow scopes and in such narrow circumstances, it would have a ripple effect on police officers and emergency workers, and that they're now having to think and calculate in liability and the potential negligence claims that could arise when they're flipping on their lights and sirens. And these are jobs where, again, there is a substantial burden placed on these workers. And so we don't want to add another calculation or cripple their use of such an important function of their job by applying this overly broad rule upon them.
So are you saying that Officer Taylor owed no duty whatsoever to Lucille not to set off lights and sirens in a place that wouldn't typically be expected, like a Buc-ee's parking lot?
Yes, Your Honor, he did not owe her a duty of care because the general injury that she sustained was not foreseeable.
Did he owe her a duty not to inappropriately use his lights and sirens?
Your Honor, it may not have been the most tasteful use of his lights and sirens, and we will concede that. However, that doesn't establish that there was a duty. So in this case, there isn't a duty because there's no foreseeable injury. As you mentioned, she's in a Buc-ee's parking lot.
Doesn't the fact that he turned the lights in your whole argument about the risk calculus show that it is foreseeable because a police officer is aware of this already when he turns on the lights?
Your Honor, a police officer may be aware of the fact that lights and sirens may alert.
Doesn't that show foreseeability?
It doesn't show foreseeability, Your Honor, because it's not foreseeable that a person's going to have any type of general injury by lights and sirens being turned on in a Buc-ee's parking lot. We're taught to anticipate that lights and sirens can occur at any time. You can be in your home and hear them, or you can be at a store and hear them, and you can even be at a Buc-ee's parking lot and hear them. But that doesn't create this volatile reaction that Lucille had. That's just not a foreseeable reaction to these lights and sirens.
So, Counselor, police officers are liable for negligently driving their cars or operating their vehicles, just like regular people like you and me, they are, correct?
Yes, Your Honor.
So the fact that Officer Taylor is a police officer, should it make a difference?
Your Honor, in this case, it shouldn't make a difference because he was operating his car as a normal person would. He was not necessarily in an emergency situation, as we've stated. And therefore, as this court noted in Hatcher versus Mewborn, he has an ordinary duty of care to not create a foreseeable risk to another person. And as I've stated, there is no foreseeable risk in this circumstance. It's just generally known that you're going to have loud noises at a Buc-ee's gas station. So it wasn't a foreseeable injury in this circumstance. So in conclusion, it's because the Balboa Bay bag ban is not in direct conflict with state law, that it is not preempted. And because Officer Taylor, there was no foreseeable injury, Officer Taylor did not owe a duty of care to Lucille. And it is for those reasons that we ask you to affirm the appellate court's grant of summary judgment. Thank you.
May it please the court. My name is Natsumi Covey, and along with my co-counsel, Melissa Fulmer, I represent the respondent, Lindsay and Lucille Bluth, in the present appeal. There are 4 issues for this court's consideration on review. I will be addressing the first 2 issues before this court: that the motion for en banc reconsideration was timely, and that the Court of Appeals did not have interlocutory appellate jurisdiction because there was no substantive ruling in order to confer permissive appellate jurisdiction. And should the courts reach the merits of this case, Ms. Fulmer will demonstrate that this court should hold that the Balboa Bay's bag ban is preempted by the Texas Solid Waste Disposal Act, and that the petitioner did owe Bluth a duty of ordinary care. Your Honors, this court should affirm the decision of the 15th Court of Appeals and dismiss this case for the want of appellate jurisdiction for the following 3 reasons. First, the plain language and liberal construction of Rule 49.7 renders the motion for en banc reconsideration as timely. Second, the city was required to provide a controlling question of law in order for the appellate court to obtain jurisdiction over the interlocutory appeal. And finally, Your Honors, the city's petition for review to this court has invoked the court's duty to review the jurisdictional questions. Now, turning back to the first reason why this court should affirm the decision of the 15th Court of Appeals, that the plain language and the liberal construction of Rule 49.7 renders the motion for en banc reconsideration as timely. There are 2 different parts of the Rule 49.7 which we ask this court to direct its attention to. The plain language in 49.7 first in part provides that the motion must be filed 15 days after the court's order. The order language that this part of the statute is referring to the order which is denying the motion for rehearing. Now, the record provides on page 6 of the record that the respondent filed a motion for en banc reconsideration 15 days after the panel issued its order denying rehearing. So according to the plain language of Rule 49.7, that in itself is enough to meet the requirements that the motion for en banc reconsideration was in fact timely. Her mic is. I apologize, Judge, your mic is muted, so I can't hear you.
Let me start over. I apologize. When Rule 49.7 provides that the en banc motion was timely when the motion is permitted, and if the Court of Appeals granted that motion, doesn't it mean implicitly that the Court of Appeals permitted that motion?
Absolutely, Your Honor. Our position is actually that the motion for en banc reconsideration was in fact timely. So we agree with you that within that when permitted language provided in the rule, that the motion for en banc reconsideration was timely. Now, I understand that this court may have some confusion on what each party's position is as far as the motion for en banc reconsideration goes. So I'd like to walk through the timeline and the procedure very quickly to explain why our position is that the motion for en banc reconsideration was in fact timely. As the respondents, we represent Lucille and Lindsay Bluth. Lucille and Lindsay Bluth were the ones who filed for the motion for en banc reconsideration. It is in our interest, in our best interest for the case before this court today, for that motion to be held as timely, because the motion for the en banc determination by the court was in our favor. So we would like this court to uphold the decision within the en banc court holding in our favor. Now, that's why the motion for en banc reconsideration, that's why our argument is that it is timely. Now, I understand there is some confusion as far as the city's petition for review and why our position is that the city's petition for review could go forward. And our reasoning behind that, Your Honor, is as far as the city's petition for review goes, the city's petition for review is not a determination on the merits. That is simply a vehicle for jurisdiction. So as long as this court uses the petition for review as a vehicle to exercise jurisdiction over that case to determine in our favor that the appeal was not properly perfected, us as the respondents and who filed this motion for en banc reconsideration timely have no problem with this court exercising jurisdiction over the city's petition for review.
Counselor, correct me if I'm wrong here, though, but in the Court of Appeals, you benefited from the court implicitly deciding that your en banc motion was timely, correct?
Yes, Your Honor.
But here in this court right now, you're trying to benefit from this court deciding that your en banc motion was not timely.
No, Your Honor. Our position as the respondents is that the motion for en banc reconsideration was timely, period. There is no, our position is first that the motion for en banc reconsideration was timely, not just because of the plain language of the statute, Rule 49.7, but also because of liberal construction. We are not arguing that the motion for en banc reconsideration was untimely. In fact, as I stated just earlier, as the respondent, we are absolutely okay with the city's petition for review being permitted because the petition for review is not a substantive determination. The city's petition for review is a vehicle for jurisdiction. And if this case wants to review the jurisdictional case, that window into that door into this court to determine those jurisdictional issues, we are absolutely okay with this court exercising jurisdiction over that. However, it is our position.
Walk us through your liberal construction argument, because that caught my attention.
Absolutely, Your Honor. If this court does not accept the plain language argument that we are presenting, we ask this court to couple that with liberal construction. The plain language argument coupled with liberal construction should show this court, and the jurisprudence of this court has actually continuously applied procedural interpretations which construe any ambiguity in favor of preserving the appeal. So we see that this when permitted language has caused some back and forth and some arguments on both sides. But in fact, Your Honor, this when permitted language did implicitly allow this motion for en banc reconsideration to be timely. And if there is any ambiguity behind that timeliness of that motion, this court under liberal construction and the procedure that this court has applied within its jurisprudence under liberal construction should hold that the motion for en banc reconsideration was timely. And we actually see that in different cases, Your Honor. This court decided in Vergbert versus Dorner that to construe the rules of appellate procedure reasonably, yet liberally, so that the right to appeal is not lost by imposing requirements of absolutely necessary to affect the purpose of the rule. And when we look to the purpose of these rules, Your Honor, we would actually look to civil procedure, or the Texas Rules of Civil Procedure, Rule 1, where Rule 1 states that the objectives of these types of rules is to obtain a just, fair, equitable, and impartial adjudication of the rights of litigants under established principles of substantive law. And these rules shall be given liberal construction. This court has taken its jurisprudence and the Texas Rules of Civil Procedure, Rule 1, and held that this court should never waver from the principle that appellate courts should not dismiss an appeal for the procedural defect whenever any arguable interpretation of the rules of appellate procedure would preserve that appeal. So we are asking this court, Your Honors, not just to look at the plain language within Rule 49.7, but also to look to liberal construction, which this court has applied within its jurisprudence when there is any type of ambiguity or any type of back and forth about what a rule could mean in the procedural aspect, and give deference to giving the appellate jurisdiction to the interlocutory appeal in front of the 15th Court of Appeals. Which actually brings me to the second point, Your Honors, that this court should affirm the decision of the 15th Court of Appeals in regard to the second issue, that the city was required to provide a controlling question of law in order for the appellate court to obtain jurisdiction over this interlocutory appeal. Now, the petitioner had the opportunity to litigate this case in front of a fact finder in order to obtain that substantive ruling. However, what the petitioner is attempting to do in this case is bypass the fact finder and go directly in front of the appellate court. Now, the argument could be made, Your Honors, that that is what a permissive interlocutory appeal is meant to do. However, the Court of Appeals has held, for example, the Waco Court of Appeals in Broski versus Ayers has held that appellate courts can only address actions taken by the trial courts, which means that interlocutory orders cannot involve a controlling question of law until the trial court has made a substantive ruling on the controlling legal issue in the order. We see that while the order within the record today does state that the trial judge stated that there is a controlling issue of law and that there is no explanation, but it states explicitly that there's an immediate appeal may materially advance the ultimate termination of litigation. It does not explicitly state the controlling question of law, which is required for the appellate courts to exercise its jurisdiction. It is true, Your Honor, that most of the courts, almost all of the courts of appeals, have actually looked at this same issue and has determined that there should be and must be a controlling issue of law stated within the order explicitly, or at least that it is apparent from the record that that is the controlling question of law that the appellate court would be exercising jurisdiction over in order to determine. However, in the case before...
Counselor, so if courts of appeals have stated that without the trial judge making a substantive ruling on the controlling question of law, then any opinion issued by an appellate court would be advisory. But why would an appellate court's decision be advisory under those circumstances?
Your Honor, we as the respondent, we actually disagree with that statement as well. That's not an argument that we're going to make before this court today, because we don't see those types of opinions as advisory opinions. We understand that the Texas Constitution provides against that. Our position is that the rule itself provides that that the controlling question of law must already be provided. Our second position, if this court does not accept that explicit or the plain language argument, is that the courts of appeals have held that it should at least be apparent from the record. Our position is that even if the court were to render these types of opinions, that it would not be an advisory opinion just because the order itself does not have a controlling question of law. I understand that that is a concern within the Court of Appeals, but it is not the respondent's position that that is an argument that we would make before this court today. In addition, Your Honors, we see that this court has held in CHS Holmes versus Perez that a permissive appeal provides an exception that allows immediate appeals before final judgment in the narrow instance that where an issue is so important that the answer cannot wait until the case is closed. Now, while that is true, Your Honor, the court further held that this court has held that the petition for permissive appeals must meet precise substantive requirements because it is this narrow exception. In order to fit into these narrow exceptions, the orders must follow these statutory requirements. And the order before this case today did not follow those statutory requirements. One of the most important requirements, as I stated earlier, is that substantive ruling by the trial court on the controlling question of law that forms the basis of the appeal itself. If we look to the record in this case, Your Honors, we see that the Court of Appeals punted this case into the appellate court. Now we see that because of that, there are fact issues that may be at dispute, which go directly to the substantive issues that must be determined before this court. And so we are asking this court to adopt the plain language of Rule 49.7, coupled with the liberal construction to determine that there are certain parameters that must be met within this order for the court to exercise jurisdiction over these types of cases. And the city was required to provide that controlling question at the trial court level in order for the appellate court to obtain jurisdiction over this interlocutory appeal. Further, Your Honors, we see that the First Court of Appeals and the Fourth Court of Appeals have also held in Double Diamond Dell Incorporated versus Wilkinshaw. And the Fourth Court of Appeals has held in Gully versus State Farm Lloyds that the trial court's substantive ruling on a question of law must be affirmatively stated in the order to be appealed, or at least be apparent from the record, as I stated earlier. The trial court in this case is attempting to relieve itself of the role of deciding substantive issues. And the court, the Dallas Court of Appeals in Gully versus State Farm Lloyds held that Section 51.014D is precisely trying to avoid the trial courts from navigating that type of determination. And lastly, Your Honors, I'd like to speak very quickly again on the city's petition for review and our position on that. While I understand that there is some ambiguity and some confusion upon that, our position as the respondent is, again, that the city's petition for review, as long as it is used as a vessel to exercise jurisdiction to determine that the appeal was not properly perfected, the respondent understands that the city's petition for review may be granted by this court. And for those reasons, we ask this court to affirm the decision of the 15th Court of Appeals. Thank you.
May it please the court. My name is Melissa Fulmer, and I also represent the respondents, Lindsay and Lucille Bluth, in this appeal. Your Honors, even if the court reaches the merits of the last two issues, this court should affirm the trial court's denial of the city's motions for summary judgment pertaining to the last two issues. Regarding the preemption issue, the trial court correctly held that the Texas Solid Waste Disposal Act preempts the bag ban with unmistakable clarity. And regarding the duty of care issue, the trial court correctly held that Officer Taylor owed Lucille Bluth a duty of care. Turning back to the preemption issue, there are three reasons that this court should hold that the Texas Solid Waste Disposal Act preempts the bag ban. First, the Texas Solid Waste Disposal Act expressly precludes municipal bag bans such as the one in this case. And second, even absent that express provision precluding bag bans, ordinance cannot escape preemption simply because it has distinct purposes from solid waste management. And third, the legislature's intent to regulate single-use plastic bags dominates any policy considerations in favor of local control. In Payne versus Massey, the Texas Supreme Court recognized that cities like Balboa Bay are political subdivisions of the state and are allowed to create ordinances that are consistent with the authorities granted to them and conferred to them by the state. However, local governments are prohibited from creating ordinances that are inconsistent with state law. And here, the petitioner may argue and assert that there is a presumption of validity that is granted to local ordinances. However, this court has recognized in Puerto Rico versus Franklin, California, tax-free, that this presumption does not exist when an express provision is present that precludes the type of ordinance in issue. And that is exactly what is present in the instant case. Here, the Texas Solid Waste Disposal Act expressly precludes the bag ban. Specifically, Section 361.0961 of the Act contains a provision that prohibits local governments from adopting ordinances that, quote, prohibit or restrict for solid waste management purposes the sale or use of a container or package in a manner not authorized by state law. This provision is a signal from the legislature that bag bans are to be governed exclusively by state law and not through a patchwork of local ordinances. And as stated in that act, the Texas Commission on Environmental Quality is granted the authority to initiate enforcement actions regarding solid waste disposal. Hence, it is not for these local ordinances to create inconsistent rules with state law to govern solid waste management. And any uncertainty regarding whether this provision applied to this case should have been resolved when this court issued its opinion in City of Laredo versus Laredo Merchants Association in 2018. In that case, the City of Laredo attempted to enforce an ordinance identical to the one in this case. City of Laredo had banned plastic bags from being distributed at points of sale, just like the city does in this case, which is preventing businesses from distributing plastic bags at points of sale. And there the court found that, or held that Section 361.0961 of the Act was an express preclusion against that ordinance in Laredo. And here, because the facts are indistinguishable from that case, this court should similarly hold that that provision from the Texas Solid Waste Disposal Act applies to this case and preempts the ordinance here. But even absent that express provision, the court should still hold that the ordinance is preempted because a ban cannot escape preemption simply because it has alternative purposes from solid waste management. Now the petitioner.
So I'm wondering if your reading of Laredo is a little overly broad. So for example, cities have ordinances preventing fireworks within a city limit, correct? And if the fireworks are used, then they're solid waste. Are you saying that if an activity like the use of fireworks results in solid waste, the city can't regulate them because there is some solid waste? I mean, the statute says for solid waste management purposes, not with solid waste management purpose, or not with solid waste effects, correct?
Yes, Your Honor, but we disagree with that hypothetical that you suggested. There is a clear disconnect between the purpose of the ordinance and the Texas Solid Waste Disposal Act. Those are distinct enough that they might be able to coexist. But here, this is not, we disagree that it's an overly broad reading, because this court looked to a bag ordinance exactly like the one in this case and determined that the act applied there. The only difference is that the city purports this to promote aesthetic purposes. But even then, this court stated in Laredo Merchants Association that alternative reasons cannot save an ordinance from preemption, or the legislature has made it clear that it intends to exclusively regulate that subject matter. Specifically, Laredo tried to make the same argument by stating that other independent and distinct purposes existed that saved it from, that were aside from solid waste management. But this.
So in the phrase solid waste management purposes, whose purpose should we consider? The city council as a whole, the author of the bill, the proponents of the bill?
Here we're considering the purposes of the local ordinance, and that is what that language pertains to. And the court recognized in Laredo Merchants that alternative purposes cannot save it from preemption, because achieving those purposes has the effect of preemption. Here, specifically, the city purports that it wishes to obtain aesthetic and safety goals, but plastic bags are not aesthetically pleasing when they become waste, and similarly, they do not pose a safety hazard until they become waste. Simply put, there is no way for these two laws to harmonize with each other, and as this court stated, local ordinances cannot coexist if it steps on the legislature's toes. And even if the court agreed that the city's purposes were valid, the act already regulates the conduct necessary to achieve those goals, which goes to what I stated earlier. The legislature must also authorize the manner in which the city obtains the purposes that it wishes to achieve through its ordinances. In Laredo Merchants, the goal was to control the generation of solid waste on the front end. And that is what conflicted with the Solid Waste Disposal Act. But here, by controlling the distribution of single-use plastic bags at points of sale, the city is doing the exact same thing. It is trying to limit the generation of solid waste at the front end so that they are not improperly discarded at the back end. And going to the third reason that this act is preempted is simply policy arguments that are in favor of enforcing local control cannot hold weight where the legislature has already indicated its intent to preclude these ordinances. Contrary to the petitioner's position, the legislature has already presented its interest in promulgating uniform regulations concerning solid waste and plastic bags. And as Justice Guzman's curring opinion stated in Laredo Merchants, the judge's task is to analyze and interpret statutes in a manner that effectuates the legislature's intent. To quote him, "It is the legislative branch and not the judiciary that bears the task of making these complicated policy decisions." Thus, regardless of what the benefits are of local control, this court should look to the legislature's intent and see that the legislature has regulated this subject matter of solid waste management so pervasively that the two laws cannot coexist. And Your Honors, moving to the fourth issue, there are two reasons that this court should affirm the trial court's denial of the city's motion for summary judgment regarding duty of care. First, as a police officer, Officer Taylor owed a duty of reasonable diligence to persons such as respondent. And second, fact issues exist that preclude summary judgment. Justice Galvan, you stated that Texas courts have recognized that lights and sirens on a police vehicle intend to catch the attention of those around them. And thus there are cases from Texas courts that have stated that there are foreseeable risks of harm that arise when an officer improperly uses those lights and sirens on their vehicles. For example,
how is it foreseeable that turning on lights and sirens on a police car, that a pedestrian would trip over a discarded plastic bag?
Your Honor, that goes to what I stated about lights and sirens intending to capture the attention of those around them. The Corpus Christi Court of Appeals described lights and sirens as warnings of the dangers of police action or an emergency. Thus, it is
a plastic bag on the ground a police emergency?
the plastic bag is not the emergency, but that the respondent would be caught off guard by those lights and sirens because she may have perceived an emergency. That is the foreseeable risk. And this court has stated that it is not the exact sequence of events that has to be foreseeable. Rather, it is the general risk of harm that informs this court's decision-making as to whether a duty exists. And here, Officer Taylor has undergone specific training, special training that trains him to serve and protect the community. And several Texas police departments instruct that police officers have a duty to only activate their lights and sirens during times of an emergency. Thus, Officer Taylor here deviated from that standard of conduct and created that risk of harm for the respondent. And Your Honors, the second reason that this court should affirm the trial court's denial of that motion for summary judgment is because even if foreseeability is at issue, that is a fact question that should have been determined by a finder of fact and not resolved through summary judgment. This court has long established that the standards for reviewing a motion for summary judgment must be viewed in the light most favorable to the non-movement. And in this case, that would be the respondent. The respondent is the non-movement, and thus this court entertains all reasonable inferences to be resolved in doubt of the respondent's favor. And although the existence of duty is a question of law, whether it exists relies on that question of fact of foreseeability. And courts have recognized that where there is a question of fact influencing the question of duty, it is more appropriate for the finder of fact to resolve that question before the court creates that duty. And this was seen in a case from the San Antonio Court of Appeals, City of San Antonio versus Riojas. There, the city had appealed the trial court's denial of a plea to the jurisdiction. And on review, the city attempted to discredit the causation element of the facts in that case, which also related to a police officer's misuse of lights and sirens. But the Fourth Court of Appeals, reviewing the plea to the jurisdiction under the same standard used for summary judgments, found that eyewitness opinions presented more than a scintilla of evidence that the wreck could not have occurred but for the officer's negligent conduct. And for this reason, the court found that Riojas had raised a fact issue precluding that grant of summary judgment. And here there is a similar issue. If indeed foreseeability is if foreseeability is contested, then that is a fact question that should be resolved by the finder of fact before this court determines that there is a legal duty. And this court has also seen this stated in Mitchell versus Missouri, Kansas, Texas Railroad Company, that resolving that question of foreseeability is more appropriate before the court determines that issue of law under duty.
So, Counselor, I'm curious, did Lucille have a duty to avoid harm herself by watching where she was walking?
Yes, Your Honor. This court has actually recognized that pedestrians owe themselves a duty of reasonable diligence. And thus, the respondent is attempting to deflect the duty upon Officer Taylor when she herself had a duty to maintain reasonable care while walking through that parking lot. But that does not erase the fact that Officer Taylor had a duty himself. And that is because the injury was foreseeable and Officer Taylor's status as a police officer elevated that reasonable duty. And the court has recognized that even ordinary drivers who are not police officers also have a duty of care to maintain a proper lookout and to be aware of surroundings and prevent foreseeable dangers.
What about the person who discarded the plastic bag that she tripped on? Wasn't she more responsible for her injuries than Officer Taylor?
Your Honor, whether another cause might be more responsible does not negate the fact or does not negate the answer that Officer Taylor did owe a legal duty because that harm was foreseeable. And if not, that question of foreseeability should have not been resolved through summary judgment, but through the finder of fact. And for these reasons, we pray that this court affirm the trial court's denial of the city's motion for summary judgment. Thank you.
May it please the court, I have a few brief points on rebuttal. Now, specifically referring to the first issue, there is no need to liberally construe the language in 49.7 because when you read it in context with the rest of the rule and with the 2008 comment in mind, it's clear that the when permitted language is a reference to 49.5. Again, looking at the second sentence of the rule, the motion, the en banc motion for reconsideration must be filed within 15 days after the Court of Appeals denial, or I'm sorry, the motion must be filed within 15 days after the Court of Appeals judgment or order. Now that's a final judgment or a final order. Or when permitted, 15 days after the Court of Appeals denial of the party's last timely filed motion for rehearing or en banc reconsideration. So already that when permitted language is cluing the reader in to look at different restrictions in other parts of the rule. And what we know from the 2008 amendment is that you are to be treating motions for rehearing and en banc reconsideration the same for the purposes of the procedure and filing. And so then that directs the reader's attention to Rule 49.5, which states in order to file another motion after the denial of a motion for panel rehearing, and there has been, there must be a change in a judgment or opinion. Now, because there was no change in a judgment or opinion here, the motion for en banc reconsideration is untimely. And briefly on the third issue, the express provision cited by respondent, again, it specifically refers to ordinances passed by the city with solid waste management in mind. Now here, the city council unanimously agreed that they were passing the ordinance for the purpose of aesthetics, and therefore it was not passed with solid waste purposes in mind, and therefore it is not preempted. Thank you.